Chair.
The Honourable Todd McLean.
Mr Chair, thank you. I thought I would take another call on the discussion and debate so far. And I want to start where I started the first call to say that actually, Mr Chairman, I think New Zealanders will genuinely be enjoying this conversation and debate. And largely that's because quite a lot of the politics around TPP that we've seen over the last year is not present in the House, and I think that's a good thing when it comes to talking about trade and trade policy and the importances of trade for all New Zealanders. So I'm grateful to all members on both sides of the House for the way the discussion and debate has been conducted so far, and pledge to ensure that it's not me that changes that in my comments in the moment. I would say to Ms Genter that I largely agree with some of the sentiments she's made, maybe not all of the detail, but do also agree with her that it is important that we find ways to make the case to New Zealanders. And certainly the process we've seen of the original, the treaty examination and also the bill, and as far as the Select Committee, I think has been important. The committee's done a very good job. They did receive a lot of submissions and did their very best to allow submitters as much time as they were able to. Indeed, in the first roadshow that I held around TPP in Auckland, where there was a very large turnout, it might have been the largest turnout of the 18-odd roadshow in Hui that we did, not the largest group that I spoke to as part of the sort of 50-plus events I did around the country, but the formal roadshow in Hui, that would have been the largest one. And Ms Kelsey, from the floor, raised her concern that she wouldn't meet the deadline imposed by the committee for submissions. Well, indeed, that would be a concern, but it wasn't because the information, the document hadn't been available. For the first time, the TPP agreement was released before the legal scrub has taken place, soon after it was agreed, and long in advance of the signature. Often with other agreements, we've released it after signature to the House. And indeed, the rough text was released last year, and then I released the scrub text before signature. But I said to Ms Kelsey at the time she should get in touch with the chair. There was all of this year to have this conversation with New Zealanders and through the House. This is a place for scrutiny, and we heard soon afterwards it's a decision of the committee, but they happily extended the period of time for her and some others to make submissions. So I want to compliment the committee for their approach to this. I think it's been mature, and I think it's helped certainly in the sense of the debate here today. I want to touch on a couple of issues that members have raised, and because this is one debate of all parts and sections they're coming to vote, I will also speak about a couple of the SOPs, and I want to explain why I think some of them are not necessary, but some of the things they are trying to achieve will already be achieved, or there's another way. The first thing I would say is Mr Terakatne spoke earlier about Y262 and his concerns there, and the government shares his concerns, and that's why under TPP we are the only country that has an exclusion to be able to make decisions around Y262, at least the UPOV agreement, and implement that outside of TPP. So all other nations have made commitments and are bound by those. Many of them have already signed up to UPOV or implemented them. But in the case of New Zealand, we have carved out space for that internal domestic dialogue to take place in many areas, including with iwi, before decisions are made. We have had to say with our partners that would be, we will put things in place within 3 years. Actually, to Mr Terakatne, I think that's probably a good thing because it does give emphasis and momentum to the necessity of having this conversation. But it also is 3 years after entry into force. So roughly 3 plus 2, the government has 5 years to work through this. And that's an area, as with the treaty exemption, we carve out the right for the New Zealand government, the Crown, to meet its obligations to iwi, to Māori. And that's something that we take seriously. In all agreements for a very long period of time, in fact, there was a previous Labour government quite some time ago consulted widely on the Treaty of Waitangi exemption, and it's been in all trade agreements since then. But I would say to members, it's not just accepted by countries overseas that we have a right in New Zealand and must therefore have a right in the agreements to meet our obligations to iwi. We have to go and explain this and negotiate it, and we've been successful so far all of the time, but we shouldn't take for granted that all of those we negotiate with would merely accept that. We have to work very hard for it. I've had 6 meetings with the iwi leaders and their trade group this year to talk about TPP and to talk about trade, and committed to continuing that conversation with them. Mr. Chair.
The Honourable Todd McLean.
Continuing that conversation with them as we go forward. And I would say that the dialogue we're having again is working very well for both sides. Around ISDS, I agree with the European Trade Commissioner that she wants to look for reforms to ISDS. TPP is one of those reforms. In as far as ISDS is concerned, it's the most advanced investor state protection system that we have successfully negotiated. I accept that people will have different views on this and won't all agree with me, but this is the first one where we have openness, we have transparency, the public can see what happens, and we have carve-outs for the government. So the first area is no tobacco company can take a case against New Zealand under ISDS. Secondly, we reserve the right to pass law and regulation. And thirdly, where 2 parties of countries disagree that an ISDS case, if they believe an ISDS case would go against the spirit of what's been negotiated, those 2 countries can decide to not allow it to go forward, to dismiss it. But it is very open, it is very transparent, and in future agreements, I think we will continue to look for ways to make this more open and more transparent and better for us as we can. But the reason we do this is not to allow others to come here and to New Zealand, take issue and seek legal redress somewhere. It's so that New Zealand investors overseas can have greater certainty. Not every country of the world respects its courts or its law in the same way that New Zealand does. And it's important that our investors know that there is a framework they can work within. Then finally, Mr. Speaker, just around the SOPs, and I'll go through these fairly quickly because I don't want to take another call and deprive members of an opportunity. There are a number. So the first is from Gareth Hughes, SOP on fair use. Some submitters requested that we introduce a fair use exemption as part of the Select Committee's process of the bill, and I think this is to do with copyright. Mr. Chair, as the departmental report said, TPP does not require New Zealand to introduce a fair use exception into the Copyright Act. The introduction of the fair use exemption is best considered within the context of the wider review of the Copyright Act, and if that review takes place and happened, it would be allowed, it would actually impact upon TPP. So the place to do this, or have this conversation, not as part of TPP, just those 11 other countries, it's any wider review of the Copyright Act, and we have the space, therefore, if domestic legislation changes, for that also to impact upon TPP. So the second one from Barry Coates is that SOP would create, this is 241, would create a discrepancy between exceptions for copyright and exceptions for performers' rights in sound recordings. Look, my view is that this would lead to confusion and additional compliance costs for people wanting to use the exception in this area. And then the final one, Mr. Chair, also from Mr. Coates, is around the overseas investment SOP. Clause 69 is the power that will enable the part of TPP relating to the overseas investment to be implemented. New Zealand cannot be compliant with its TPP obligations unless regulations are made or a new bill is passed. So the regulating making powers under Clause 69 is clear on its face as to the limits of the power and the purpose of that power. It's limited to the implementation of the obligations under TPP, so limited to $200 million as a threshold for business assets acquisition. It doesn't speak to sensitive purchases or sensitive land and so on. For this reason, the government doesn't consider that it's necessary. We consider it is not inappropriate to delegate to the executive the power to make detailed regulations that we needed to meet this obligation. But the draft regulations as proposed to be made under the Clause 69 are already open for consultation. That's been called for by the Minister, and it's intended to allow transparency input from the public. The regulations, once decided, would be subject to the usual scrutiny and the other powers of the Regulations Review Committee. And as Ms Genter said earlier, it doesn't allow the amount of that threshold to go up. that's set in the TPP agreement. It merely is around the rules of how to implement it. So it doesn't mean the government can say, let's double it or triple it. It's only to allows us to implement obligations under TPP, and that's set at the rate of $200 million.